ready.
Good morning, everyone, and thank you for joining us this morning for Sara's talk. Sara, of course, is our new lecturer in competition law who joined us last year. And I know we've got this room for a very short amount of time, so without further ado, we'll let Sara kick off with her presentation. Thank you.
Yeah, thank you, Peter. It's obviously very nice to have the chance to present you my research. So this is a bit of my PhD. And I thought, considering the audience of the CCP, I thought it makes sense to start with. So I researched the legal concept of ecosystem, but obviously this concept originates in economics theory. So I think it makes sense to look at how the economic concept of ecosystem passes to the legal theory. And this is also the starting point of my research. I problematize it here. This would be like the core of the presentation, arguing that there is no actual unique legal concept of ecosystem. And I will try to provide an explanation in the thesis, but also a short explanation here. So this is, the term ecosystem is becoming more and more popular in the competition law fora. This started first through the publication of some sectoral specific literature. So here I just added some examples. For instance, we have Borgogna and Colangelo that studied the finance ecosystem. We have Kerber that studies the Internet of Things ecosystem, and in another article, in this article, so sorry, I added this one, connected cars or vehicles that can connect to the internet, and so on and so forth. And then in more recent years, the more general literature in competition law built up on these sectorial studies, and we have some articles that look at how competition law should integrate digital ecosystems, sometimes even before interrogating asking why we should incorporate business ecosystems or digital ecosystems, depending on the case. In the same period, the word gets incorporated into several soft law provisions. So just a disclaimer, my thesis focuses on the European Union, but I decided to integrate a more interjurisdictional perspective here. So the more relevant piece of soft law that we have on ecosystems is once again a sectorial document. And I guess you're all familiar with it, with the CMA market study on the mobile ecosystems. But before that, in the European Union, the Commission published the report, Competition Policy for the Digital Era, where they basically listed a set of special characteristics that the digital economy had. And they used the word ecosystem several times, mostly related to network effects and economies of scope. More recently, last year, the word has been used in the Commission's notice on the definition of the relevant market, and I will present more clearly later on how this is incorporated. But there is no, what is important here is that there is no specific definition of what an ecosystem is. Just the Commission says when we have an ecosystem, that's how we can define the relevant market. The notice on the definition of the relevant market, as it's the case with many similar documents from the Commission, basically summarizes previous case law and provides guidelines that explain how the Commission is going to apply several concepts based on the previous experience of the enforcer itself. So obviously we had case law before 2024, which incorporates the word ecosystem. In the European Union, the most famous case is Google Android. We then had several merger cases. The Amazon iRobot is one of them, and the one where the word ecosystem takes the main seat is the Booking eTraveli case. before the Commission begins using the word in digital cases. In 2020, we have the first case in the US against Google, and here the word ecosystem appears several times. But once again, I focus on the European Union. I think my findings also apply to the UK and the US. There is no specific definition of what an ecosystem is in law, in the case law, but there is also no specific definition in the regulation. So in both the Digital Market Act and the Digital Services Act, once again, the word ecosystem appears. I focus here on the Digital Markets Act because it's a piece of legislation that's more relevant for competition law, competition policy. What is curious is that the Digital Markets Act tackles ecosystem. In the proposal, in the third paragraph, we have the word ecosystem. The goal of the Digital Markets Act is to counteract the power of big digital ecosystems. However, in the actual text of the regulation, there is no mention of ecosystems. Instead, the Commission decides to introduce the concept of gatekeeper, which did not exist before and for which we do not really have relevant case law. We still have the multiple mentions to ecosystems in the recitals. And what is interesting is that, as you can see, again, going back to the case law in 2023, the Commission issued the first decisions based on the DMA, basically nominating the gatekeepers. And in multiple of these decisions, the parties argued that the Commission, the goal of the DMA is, according to the reciters, to fight the power of ecosystems, especially in the ByteDance decision. And the Commission remarks that this is not the goal. The legislation targets gatekeepers, not ecosystem. However, there is a certain amount of confusion because the word appears just not in the articles. And then here we have a ghost appearance, which is our Digital Markets Competition and Consumers Bill, which targets similar companies as the DMA does. However, we do not have any mention of ecosystems. So it looks like progressively this word became very, very trendy in the 2020s, and then it looks like its success is kind of declining, at least in the hard law. What are ecosystems? Where do they come from? Where is this concept imported from in law? The concept obviously comes from economics. Before economics, it comes from biology. So it's a very successful metaphor that is able to cross disciplines. In an article published in 2018, De Vasconcelos analyzes the main contributions to the literature on ecosystems. It is not an all-encompassing graph, but I think it's quite nice because it shows, first of all, the multiple scholars active in different fields of economics engaged with the concept of ecosystem. We have, obviously, the core is based by what here the authors called scholars engaging with the ecosystem construct. Most of them relate to the strategic management literature. Then we have what I refer to as the innovation literature, so scholars that look at open innovation and product platform. And here these scholars also build on the work on the platform economy. And then strategic management, but also evolutionary economics and organizational studies. What is interesting, I think, is that these scholars are related one to another. So the concept is defined in a specific field. I will, as I will show in a minute, we have different definitions of ecosystem in different strands of the economic literature. However, the multiple collaboration makes so that these definitions are sometimes overlapping and interacting. What are those definitions? First of all, I identify four main meanings of the term in economics. First of all, what I refer to as the business ecosystem. The business ecosystem comes from the strategic management literature. It's introduced here by Moore in 1993, and it's a quite vague concept to begin with, and then it becomes more and more detailed, and it relates basically well, in their article, De Vasconcelos also analyzes the words that are most used by each strand of the literature, and in the business ecosystem area, we have words such as strategies, such as capabilities, and so on and so forth. So basically, the business ecosystem literature focuses on how on how firms can beat competition, can gain a competitive advantage by managing their ecosystem. The focus here is on value capture rather than on value creation. The focus is on value creation when we're talking about innovation ecosystem. This strand of the literature is associated towards such as obviously innovation, but also open, and looks more at how multiple players can, or complementarities, and looks more at how multiple players interact with one another, cooperate in order to create more value. The two concepts are quite related because obviously in sectors where innovation, in innovation-intensive sectors, being able to support, to create and sustain an innovation ecosystem may give you a competitive advantage and make your ecosystem more successful. However, scholars look at different players, so the boundaries of ecosystems are different. So the first scholars looking at business ecosystems usually focus on one leader and its complementors, and look potentially at other leaders of other different competing ecosystems and their complementors. While scholars that focus on innovation ecosystems have a much wider outlook on all of the players that can support and participate together to the innovation enterprise. So the boundaries are a bit more stretched in the second case. Then we have two kinds of ecosystems that I'm not going to focus on, but maybe they resonate with you, and just for you to know, this is not what we're looking at in competition law. First of all, there is the digital ecosystem. Now, the digital ecosystem was part of the competition policy discussion for a certain amount of time. We see that the word ecosystem became successful together with digital cases. So obviously we're looking at digital ecosystems. However, scholars that focus on digital ecosystems focus on basically the technology-enabled infrastructure that supports the ecosystem. Now, at the beginning of the 2000s, Rocher and Tirole published their very, very famous paper on multi-sided markets and multi-sided platforms. And in 2019, 2020, we have a few articles in competition law that try to incorporate the teachings of the paper into competition policy. So the literature on platform enters competition policy. However, platforms and ecosystems are two different concepts. Platforms enable the creation of an ecosystem, but platforms per se are not ecosystems. And then we have the data ecosystem, and here a certain part of the innovation of the competition law literature engages with the concept, especially when relating it to data sharing, which can be a possible remedy that is imposed on mergers. The economic literature on the data ecosystem focuses on how data can be made more available for everyone. So how do you incentivize more players to actually take part into these collaborative infrastructures for the sharing of data? Yes?
So Sara, the digital ecosystem, if there is a merger on the cloud computing, for example, does it mean that that is changing completely the ecosystems that is in place? Because you have two platforms, for example, that they use two different, say, cloud computing or two independent cloud computing. That could be thought in that definition as different ecosystems, not platform, not ecosystem, but it could be thought as two different ecosystems.
Yeah.
But if there is a merger that takes place on the cloud computing, that will make this platform be part of the same ecosystem.
Yeah, it's probably, well, it depends on the kind of merger, right? If we're looking at an horizontal merger, as I think that's the case, then instead of having two competing ecosystems, you have one single ecosystem. And here it really depends on how you define the boundaries of ecosystems, because you will have complementors that basically multitask between different platforms, so they will already be part of both of the ecosystems. However, when you put them together, then they're only part of one single ecosystem, right? So if you look at the business ecosystem, you look at
the other fund,
yeah.
Okay. Because of relying on the infrastructure. But
yeah.
Once you change the infrastructure, you're modifying the definition of the
yeah, I think, I don't know if I worded it properly. What I mean is more that scholars in the digital ecosystem focus on how different kind of infrastructures can enable the participation of different players and then shape different kind of ecosystems. So they do not really look at like what happens in the case of a merger, because they do not focus on competition policy. Yeah.
We've just got a comment from Peter Mosley. I'll just invite him to come online and speak.
Hi, Sarah. Sorry, you might answer my question later on, but just looking at this slide, I was wondering if I've up to now I've had a wrong definition of ecosystems in my mind. So to me, ecosystems is kind of I've always thought of it in this context in digital markets as one of the useful new kind of terminologies that unlike some other ones which are kind of just slightly bit more meaningless. This actually has got a lot of meaning, and to me this was a little bit similar to conglomerate markets. So you've got one firm that that is active in lots of different markets, and in the old days, these markets wouldn't have been considered to be related horizontally or vertically, and in these old days, there was something called conglomerate theory of harm, but that wasn't really very often used. And so I thought this is actually a really useful thing to have in digital markets, this thinking about these conglomerate markets as an ecosystem, where we have the same firm that is doing very different things in very different markets, and seemingly you would think, well, what's the competition harm? And probably there isn't anything until we start thinking about these seemingly unrelated markets as an ecosystem, and there comes in all the kind of the thinking about ecosystem theories of harm. But none of this seems to be reflected in any of these four definitions, on the slide. So I don't know. Am I completely in the wrong here? Sorry.
Yeah. Okay. No, you're not completely in the wrong. So conglomerates, like the discussion in competition policy, the discussion on ecosystem goes really hand in hand with what conglomerates are, especially when we're looking at mergers, and especially when the decision on booking a travel came out. Some scholars argued that this basically the Commission was introducing an ecosystem theory of harm, while others were just saying, well, this is basically a typical conglomerate case, right? The main difference between conglomerates and ecosystem is that basically in ecosystems we have very strong interdependencies between the different layers of the ecosystem, while in conglomerates, basically each operation in each market is more independent from one another. At least this is what emerges from the theory on business and innovation ecosystems. So conglomerates are definitely related to ecosystems, but I would argue that the strategic management and innovation literature on ecosystems does not actually start from conglomerates. On the contrary, I think it's more, but don't cite me on that, but one of the main scholars focusing on introducing the concept of ecosystems highlights how ecosystems basically come from the disaggregation of a product. So, for instance, one typical example is the IBM 360 computer. Well, basically, the same company, IBM, starts introducing a modular architecture so that you could actually purchase different pieces of the computer without having to change the whole computer, so you could upgrade the computer. And then some workers, some employees of IBM decided to found a competing company that would offer only one component, so it would marginally compete with IBM. And so this process is a kind of a process of disaggregation of a complex product and service that is offered by multiple entities, because this gives a competitive advantage, or because depending on the lens that you adopt, or because this enables quicker and more successful innovation, or more disruptive, depending on what the goal of the ecosystem is, rather than the conglomerate example tells us that basically the conglomerate arises because of the expansion of a firm that starts selling one product and then sees that there is an opening in another market, and basically expands their operations in different markets. So I would argue
sorry, I did not want to sorry, maybe my explanation was really just quite bad. Yeah, absolutely. I don't disagree with that. Yeah, conglomerates is a different thing. To me, that's kind of the starting point. As I said, we used to have conglomerate theory of harm. We moved on because there is a realization that the potential harm comes from the fact that these seemingly unrelated markets behind them is the same business, and there is a lot of interaction because of data, because of scale and scope and all these economies. So no, I fully appreciate this, but in my head, the main thing was always that there is some sort of economic link. Most often it's the same business. For example, Google doing a lot of different things, and of course they use the massive advantage they have on one market to then become dominant on a totally different market. So there's some sort of single entity doing it. And why I was a little bit confused, because these definitions are about cooperation and competition. So that to me seems very distant, but maybe I just didn't pay enough attention.
No, I think you're right. They are very distant. And some of these scholars, when the few of them that I was lucky enough to meet at conferences, they are all very surprised when they hear in competition law people talking about just the firm and basically Amazon and Amazon Prime as part of the ecosystem, as opposed as having Amazon Prime, obviously, but also the sellers on the platform as being part of the ecosystem. So I think this is actually, you pointed one of the problems that I see with the concept, that the boundaries of the concept are really blurred, and depending on which field you come from, you might give for granted that the concept encompasses different entities.
Okay. Okay. Thanks. I'm sorry for interrupting you.
No, it was very useful, and I think it gave me the chance also to anticipate some concepts. So these two concepts, the business and innovation ecosystems, are the ones that I focus on, and the reason is that there is a high degree of collaboration between scholars in these two fields and competition lawyers and economists. So when the concept enters into competition policy, it does so in two ways. The way that stands more clearly from what I've said until now is that basically ecosystems are endangered environments that are in a very delicate balance. So if you would basically regulate one dimension of this environment, you would risk incurring into a butterfly effect. You don't really know what kind of damage you could do to the whole system. And at the same time, scholars such as Petit and Thies or Petsikas that also collaborated with Thies highlight that in ecosystems, in business ecosystems, the competitive pressure comes from different sources. So we do not only have competition in the market, but we also have out-of-market competition. And I will add here that from this strand of the literature, it is clear that there are multiple dimensions to competition. So I will refer to, they're called in different ways, but within the presentation, I will refer to inter-ecosystem competition, obviously competition between different ecosystems, intra-ecosystem competition, so competition between the leader of an ecosystem and their complementer at the vertical level, and horizontal intra-ecosystem competition, which is usually competition amongst true complementers that, for instance, true sellers on Facebook Marketplace. But obviously, different scholars use different terms, just to be clear, that's what I would use. So this is a very positive vision of digital ecosystems, and it entered competition policy, mostly with these OECD documents published by pertain in 2020, but it's counterbalanced by what Peter was mentioning. There is this idea that basically ecosystem leaders are basically sharks that expand and eat everything. So the first paper on ecosystems, the Moore paper that I mentioned before, it was called Predators and Prey. And it's quite funny because that's not, the idea that emerges from the paper is quite distant from this competition policy of idea that basically ecosystem leaders are predators that prey on small startups or smaller complementers. But obviously this idea entered competition law and mostly through the works of Annabel Gower, collaborating with Sinamo and Jacobides. And this trend builds more soundly on the existing literature on platform, so looks at how different cases have been resolved by looking at multi-sided markets, especially starting from the financial payment platforms cases in the US, and focuses on the existence of that economies of scope. And according to this trend of the literature, basically the concept is useful to basically establish new theories of harm. Ecosystems are basically unveil a new level of danger. There are some fundamental elements of ecosystems that emerge from this competition law and the competition policy at large literature, and they basically pass from the existing economic literature, so they do not come into competition law out of nowhere. And here I use a summary which was made in an excellent article by Philip Arnanger in 2023. And the main elements are modularity, complementarity, and a visible imagination of the future. But beyond these elements, we do not really have a unique definition in the literature. Every author defines ecosystems in different ways. So it can be sometimes quite confusing to try to understand which kind of players are involved in different visions of ecosystems. So the concept of ecosystem emerges as more of a metaphor, and that's something that Moore stated in an article of 2006, not in relation to competition law, but basically, according to him, and mind he was the person that introduced the concept to the strategic management literature, the strength of the concept is that you do not need to define it. It allows you to expand the analysis to players that were previously not part of the analysis. Well, if it's useful for law or not, we will see that in a minute. I will go quite quickly here because we don't have a lot of time. I also think you're all quite familiar with the specific characteristics of ecosystem. Just for you to know exactly what I'm referring to, when we're talking about complementarity, we are talking about multilateral, non-generic complementarities that are not fully hierarchically controlled. And this goes a bit against this idea of like there is one leader that controls everything. In theory, if we think about, for instance, again, I will use the Amazon example, so we carry this with us. A marketplace with no sellers on would be absolutely useless. So the complementaries are multilateral, also market conditions may sometimes make so. Yeah.
Does it matter that complementarity comes from the demand side, the example you were trying to be, versus the supply side, the scope, or you still get complementarity, but one is driven by cost function, the other is driven by demand.
I would say that I think this is too much of an economic question, so maybe I will ask you afterwards. So like, yeah, I will ask you afterwards, like, to expand exactly what you mean. But like, if we're talking about complementarities that come from both sides, like they're non-linear, they come from both sides. So there has, I would say that it has to exist both the demand side complementarity and a supply side complementarity. But then I would imagine that in most ecosystems, one drives the existence of the ecosystem more, right? So I suppose you refer like to how this is reflected in different prices for the two sides of the platforms or not, but I'm not really sure. So if you don't mind, I'll just leave it for later. Then another fundamental element is modularity. So I already talked about the example of the IBM 360 computer. Basically, this comes mostly from the innovation management, from the innovation literature. I think working with modules allows firms to coordinate more complex products. So if everyone only works on a component rather than on the whole product, innovation becomes easier, organizational complexity is reduced. And what is relevant here is that the ecosystem leader or the standard setters basically govern this, what can be called thin transaction points between the modules. And that's where their power stems from. They regulate interoperability. And then the last element that emerges as like recurrent in this literature is orchestration. And this is strongly related to the position of the leader. Basically, the leader has the duty to orchestrate the resources, and depending on how it decides to do it, this determines the shape that the ecosystem will take. So the ecosystem can be open or can be closed, depending on how our resources are managed, orchestrated, and allocated between the different members. Obviously, orchestration can also emerge in a spontaneous way, especially scholars of data ecosystems focus on like collaborative data ecosystems where basically the members can orchestrate the assets. But in our field, we look at ecosystems where the orchestration is actually done by a leader, so by what is usually big firm. Well, the whole I think this shows that there are multiple ways of thinking about ecosystems, and it's true that the strength of the concept is that it's interdisciplinary and it allows us to incorporate different actors. But does it make sense to use such a concept for law, where a legal concept needs to be well defined in order to avoid legal uncertainty? There are two main proposals on how the ecosystem concept can be used in law. The first is assisting us in the definition of the relevant market. So as you know, digital markets can be sometimes tricky to define the relevant market, especially when there is no monetary price associated to the sale of a product or a service. Some scholars, particularly Robertson and Eben, started looking at whether we should look at ecosystems in some cases in order to supplement the definition of the relevant market, or even in some cases, in some instances, substitute the definition of the relevant market. So should we go to the definition of a relevant ecosystem? In the case law, the ecosystems come up basically at the stage of the definition of the relevant markets in several instances, to the point that in the market definition notice, the Commission specifies how to define the relevant market when we have ecosystems. And the solution that the Commission proposes is basically to treat ecosystems as aftermarkets or bundles. However, this vision of ecosystems allows us to incorporate different elements, like out-of-market elements, but in ways that existed before, because basically we are looking at, we have to identify a primary product, a secondary product, and so on and so forth. So it's a way of using the concept of ecosystem that is a bit far from the concept that we've seen before, how it's been defined in economics. Some scholars suggest that we could make a better use of the term in the context of the definition of the relevant market. So we could define relevant ecosystems, and the proposed tools are hierarchical clustering, K-means clustering, so various ways of basically clustering economic players, identify network of complementarities, using a factor analysis or a snowball selection. And I think these are all very interesting ideas. The problem is, how do you get data, and where do you get data from, and can this kind of analysis be applied like on a large scale? Can this become like the standard? And then another way in which competition law takes into account of ecosystems is potentially through ecosystem theory of harm. So that became a big topic of conversation after the Booking It Travely case. Once again, this is where conglomerate mergers enter into account. And the idea is that looking at ecosystems in mergers would allow us to take into account stronger complementarities and stronger interdependencies as with respect to what a conglomerate theory of harm would allow us to do. So some scholars again propose ecosystem-based theory of harms, so I will go a bit quickly here, but basically for the lawyers in the room, the idea is to adopt unilateral effects theory or entrenchment theory of harm in order to take into account of ecosystem effects. So in the first case, we're looking at horizontal ecosystem effects, and in the other case, both horizontal and vertical ecosystem effects. So the problem is that we do not have a unique legal concept of ecosystem. So all of the scholars proposed their idea, and basically the enforcers as well encompass different players when talking about ecosystem. And this makes it a potentially problematic concept to adopt in the legal arena. I decided before continuing my work on the thesis that I had to understand if there is in practice, in the literature, there is no singular unique concept of ecosystem. But from the case law, can we actually derive a legal concept of ecosystem as it's applied by the Commission? So I limited my research to the Commission cases with the idea that sometimes, like in many cases by the court, are like appeal cases. So when a new term enters, I would expect it to enter into in Commission cases. I excluded cases that relate to agriculture or environmental protection because there the ecosystem is mostly used in a biological sense. So I didn't actually open these cases, and so if there is any kind of non-biological ecosystem in these cases, I cannot, I don't know. But I collected the cases, the resulting cases that are around 205. 12 of these cases relate to antitrust cases or cartels cases, 67 to mergers, as you would expect. And then we have 20 cases that relate to DMA decisions. Now, 20 cases related to DMA decisions can appear quite surprising because we don't have as many big techs, but obviously for each big tech, we have multiple cases that relate to all of the services they offer. So we might have like 4 cases for ByteDance, 3 cases for Apple, even more, I think, for Apple. So what I found out very quickly is that you remember the slides with the 2 main meanings of ecosystem. One is like a very, very positive potential innovation environment that leads to potential innovation, and the other one very negative, so a very threatening leader that basically takes over everything else. In the cases that I analyzed, we have an equal distribution of positive, negative, and neutral meanings. This, like the distribution is quite balanced both within each case, so Article 101 and 102, and merger cases and DMA cases as well, but also over time. So we do not have a shift towards more negative meanings. And so obviously I say that by only taking into account cases in which the word ecosystem stems from and is used by the Commission, not used by the parties, because then obviously it's only used in a positive manner. So just here you have some cases which I don't think I have the time to go through. But in the first, so the Oracle case is like a case in which basically the Commission describes the ecosystem as vibrant, a vibrant ecosystem, and Oracle has an interest in preserving their reputation so that they can keep on attracting other players in the ecosystem. So here the ecosystem counterbalances the competitive threat that stem from the mergers. Then a very negative meaning is like in the Amazon, sorry, there's a typo, but here is like the Amazon ebook most favored nation case, where basically we have this idea of Amazon like constantly expanding and setting up its own ecosystem. In the, I think that's probably like a earlier version of the slide, sorry. But in the Seagate technology case, we are looking at like a more neutral characterization, where like basically the Commission says, so the company operates in the HHD business that is composed by the manufacturer of components and the users all together, simply like as a statement. So it gives the boundaries of where our analysis should go. The same for DMA decisions. Here, the word ecosystem is used in a positive sense only by the parties. The Commission uses it both in a neutral sense by describing for instance, the Apple operating system or Meta's activities, and the negative sense. Especially in the ByteDance case, it's very clear that ByteDance characterizes ecosystems as a very negative thing, saying that the goal of the DMA is actually to prevent ecosystem harm, and the Commission does not like repeats this in several instances, admitting that there is possible harm stemming from ecosystems, but the DMA the DMA looks at gatekeepers, and so the analysis should be focused on the specific market that they're looking at in the decision. So another thing that emerges is that the Commission incorporates different players from time to time into their analysis. So in the Seagate case, we have a more like innovation ecosystem literature instance of ecosystem, where we have the manufacturer complementors, and the users as part of the same ecosystem. And the opposite can be seen in the ByteDance case, or the Amazon cases, where the ecosystem only comprises the activities of the leader. So even here, it's not very clear. There is not unique meaning of ecosystem within the same Commission case law. How does the concept assist us in the definition of the relevant market? Once again, this is all quite blurred. In several instances, the parties ask the Commission to take into account the ecosystem dimension. The most famous example is here the Google Android case, where Google says that it's subject to a strong competitive pressure by the Apple ecosystem. And in all of these cases, I think this is quite relevant. The Commission admits that the ecosystem dimension can be relevant in other instances, but in that case, the definition of the relevant market is left open, or in any case, it does not take into account of the ecosystem dimension. So there is an admission that the ecosystem dimension can be relevant, but it's never actually used. Then we have a series of cases. Here you have just a few examples, but there is more, in which the ecosystem uses, the Commission uses the word ecosystem in order to look at relevant markets. So for instance, in the Comscope case, the Commission says that the wired connection and the wireless connection are part of different ecosystems, and so they shouldn't be part of the same relevant market. But once again, we have very different boundaries that are associated with the word. So there is no consistency. So once again, it looks that the word is not very useful for the definition of the relevant market. Then for what concerns theories of harm, apart from the booking a traveler, we do not have a real ecosystem theory of harm. The literature is a bit split on what happened in the booking a traveler. According to some, it's just a normal conglomerate case. Yeah. And for others, this is an ecosystem theory of harm, but it's not replicable because there is not real test that emerges in the case. In other cases, we have other theories of harm that are related to ecosystems, but once again, there is no real test. And these are existing theories of harm. So for instance, we have consumer lock-in, tying and bundling, or input foreclosure strategies. So up to this point, I would say the concept of ecosystem is not being very useful for the Commission. And it's curious that it's still there. So this is the main problem. Why is it still used? So it's not used in the regulation, ex-ante regulation, or it's not used in the articles, but then it emerges again in the DMA decisions, and it's not always introduced by the parties. So why do we still talk about ecosystems? Well, I still talk about ecosystems because that's the topic of my thesis, but why does the Commission still talk about ecosystems? Well, what I think is interesting is that there are some peculiarities of these cases that use the word ecosystem. I would say that they take into account elements that usually are not taken into account by enforcers in their legal analysis. First of all, they take into account complementarities. This is often on the demands of the parties, but sometimes it's the Commission that uses the word ecosystem in order to take into account like of existing complementarities. Most of the times, complementarities are taken into account in order to look at interoperability, and often in the case of mergers, what is the effect of the merger on interoperability obligation, if the party would have an incentive to limit interoperability or not. And then I think this is even more interesting. The Commission in these cases looks at inter-ecosystem competition. Now, inter-ecosystem competition is not a relevant part of the DMA. The DMA basically says that the existence of an ecosystem in the recitals, again, the existence of the ecosystem favors entrenchment, and so it makes the emergence of a competing platform even harder. So this is the reason for which it focuses on inter-platform competition. But in the ecosystem case law, we see that the inter-ecosystem competition emerges several times in different ways, but it basically enables the Commission to look at this dimension of competition that it would be otherwise absent from the case law. So to conclude, there are multiple economic meanings of ecosystems. Two of them passed into economic policy, but they coexist for a long time, and it is not possible to identify, to give a legal definition of ecosystem. And the concept itself seems to be of limited use for establishing a relevant market or advancing a new theory of harm, at least to date. However, the concept is still used in what I argue is a metaphorical sense. So basically, metaphors are very often used in new technology to associate what is familiar with what is not familiar. So we know, for instance, that viruses came with some characteristics, and then we use the word virus because using malware would be really confusing for people that have never heard of it. And that's the same. So ecosystems are associated with some characteristics like multi-level competition, modularity, complementarities, and they are used in a metaphorical sense by the Commission to introduce these elements into the analysis, elements that would otherwise be mostly absent for competition law. And so we are assisting to the the way in which law evolves to tackle technology. And it's not the first time that it happened. One example that I particularly like is when in 1896, to discuss the limits of locomotives on highways, which are actually cars, the House of Commons started discussing about what is the speed that makes a horse dangerous. Now, horses and cars are very different, but people were not familiar, the law was not familiar with the concept of car. And I close by saying that this basically reinforces a constructivist idea of the law. So basically, the legal language is language separated from the rest of the other languages that compose our reality, and it evolves in its own way, following its own mechanism. And I hope that this helped uncovering one of these mechanisms.
Thank you, Sara.